A lot of veterans still believe one visit to the VA, one bad form, or one old record can kill their gun rights forever. Pause. And that belief is so common, it keeps good people scared, silent, and sometimes disarmed when they may still have legal options. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from making a mistake. Hit that button now and let's get into it. Here's the truth most gun owners never hear about. When people talk about veteran gun rights, they usually jump straight to fear. They say, if the VA knows you have PTSD, you're done. Or, if you needed help with your benefits, the government already flagged you. Or even, any bad discharge means you can never touch a firearm again. That sounds dramatic. It also leaves out a lot of important facts. Today I'm walking you through 6 forgotten veteran gun rights and protections that almost nobody explains clearly. Not lawyer talk, not political spin, just plain English. And if you don't know this stuff, here's what could happen. You could give up rights you still have. You could say the wrong thing on a gun form, or worse, you could assume you're legal when one detail says otherwise. So stay with me, because the last 2 points are the ones that catch people off guard the most. First forgotten right. Getting mental health care is not the same as losing your gun rights. Let me say that again, because this myth hurts veterans every single day. Talking to a counselor, seeing a therapist, using the VA crisis line, or getting treatment for PTSD does not automatically make you a prohibited person. That means treatment by itself is not an automatic gun ban. Have you ever heard a guy say, "Don't tell the VA anything, they'll take your guns"? That line spreads fast. But here's what most people get wrong. Federal law does not say, if you get therapy, you lose your rights. It focuses on very specific legal triggers, like a formal finding by a lawful authority or formal involuntary commitment. Treatment is not the same thing as that. Here's a hypothetical example to explain this. A veteran named Mike starts having nightmares and panic attacks. He goes to the VA, he talks to a counselor every week, he gets medication, he even joins a support group, and a friend tells him, "Man, now you're on a list." That friend may be dead wrong. Mike getting help by itself is not the same as a legal order taking away his rights. And this matters for a bigger reason. Fear keeps veterans from getting care. That is dangerous. If somebody avoids treatment because they think every appointment equals confiscation, that bad information can cost them their health, their family, and their future. But here's the crazy part. The rumor sounds believable because gun law uses words people don't understand. Terms like adjudicated and committed sound vague. In plain English, those words usually point to a formal legal process. Not just a doctor visit, not just a diagnosis, and not just asking for help. Now, do not twist this into something reckless. State laws can be stricter. Court orders can matter. A specific case can change everything. But the broad internet myth that VA mental health care ends your rights is not the full story. Don't make the mistake of treating treatment like a ban. It isn't that simple. Second forgotten right. A PTSD rating or mental health disability rating is not, by itself, an automatic federal gun ban. This is the part that shocks a lot of people. Many veterans think if the VA gives you a disability rating, you are done. Whether it is for depression, anxiety, or another mental health condition, they assume that rating alone means they cannot own a firearm. Most people think rating equals restriction, but the truth is, those are not the same thing. A rating is the VA saying, "We recognize this condition affects your life." That is about benefits and compensation. It is not automatically a federal order saying, "You are now prohibited from possessing guns." Why does this matter so much? Because veterans hear one story from a buddy and one story online and believe they are criminals overnight. In many cases, that belief is simply not accurate. Let me break this down for you. A condition can be serious. It can be service-connected. It can affect your sleep, your work, and your daily life. But that alone is not the same as a legal finding that you are barred from possessing firearms. Those are different tracks. Here's another hypothetical example. A veteran gets a high PTSD rating after years of struggling. He hunts every fall. He keeps a home defense pistol in a safe. He assumes the new rating means he must sell everything immediately. Maybe not. The rating itself is not the same thing as a federal firearms disability. Now, this is where it gets interesting. The confusion gets worse when people mix up diagnosis, treatment, benefits, and legal status. They are not all one thing. One medical file does not answer every gun law question. One VA letter does not replace a full legal review. And before you think I'm saying don't worry about anything, no, I'm saying worry about the right thing. Look at the actual legal trigger. Look at whether there was a formal finding. Look at whether a court entered something that matters under federal or state law. That is where the real answer usually lives.